but a journey of continuous improvement. Good morning to one and all present. On legal aspect of business, which is conducted by Lakshya MBA Student Association. In this special occasion, I warmly welcome our faculty and students of Oral Institute of Management Studies and Subbalakshmi Lakshmibedi College of Science.
Let us commence this seminar by invoking the blessing of Lord Almighty. Let us all stand for the prayer song.
Great. Today is the another special day of us as we have invited the high profile and high voltage personality to address the gathering. We look forward and highly informative and engaging session as we have explored the legal aspect of corporate world.
I would like to invite Dhanushya from first year MBA to welcome the gathering welcome address.
Present here. On behalf of Lakshya MBA Students Association, I am indeed delighted to welcome all of you to the intellectual program on legal aspects of business. At the outset, I would like to welcome the management, principals, and dean academy. It gives me immense pleasure to most respected, high-profile guest speaker, Mr.Dinesh Kumar sir, who has cordially accepted our invitation to serve as the guest speaker for today's program. I would like to take this opportunity. I would like to take this opportunity to welcome our beloved head of the department, Dr. M. Subramaniam sir. Under guidance and leadership, we organize the program today. I would like to extend my warm welcome to the senior most professor, Dr. S. Faculty team of our Oral Institute and my fellow students. Once again,
Thank you, Dhanushya. And I will welcome our head of the department of MBA, Dr. M. Subramaniam sir, to share about a few words.
Thank you. It's a pleasure amidst standing in front of this August gathering. So thank you, Dr. Karthik Babu, for organizing such a wonderful program for the students. It will be one of the innovative kind of program for a management graduate and commerce student. I believe Dinesh Kumar knows that this is a very common practice in law colleges. Law colleges, they used to have Moot code for the students to have a practice on how to argue and how to submit their plea to the judges. It is a practice session for them in the law colleges. But for the business graduates, I trust we are doing for the first time here. Let this practice continue. We are making the first attempt. I know that it is quite challenging for the students to comprehend and understand. So we have a well experienced personality, Dinesh Kumar Nair, with us here today. So he'll be guiding us and he'll be throwing his lights on what to do, what not to do, and how to handle a case and all. So wholeheartedly, I thank Mr. Dinesh Kumar for accepting our invitation. So amidst his busy schedule, a very busy High Court lawyer, that too during the daytime, spending 2-3 hours with us is quite challenging. Only when you go to profession, you will understand the value of time. That too during the morning time, you know that the court proceedings are there. A set aside might be given to his juniors or somebody else to manage the cases. I know that he is here. So I think he deserves a round of big applause for this. I thank my faculty team, Dr. Povalendi, Dr. Shekhar, Dr. Shivajyoti, Dr. Abraham, Professor Selvam, and my corporate relation head, Maniraj, and my peers from Commerce and the BBA department. I welcome you all. I welcome all the students. Instead of investing a lot of time in all these introductory, straight we have to go to the next session. So we are eager to learn from your interaction and learning, sir. Thank you. Over to you, MC.
Thank you, sir. Now, as a token of love and gratitude, I would like to invite our head of the department, Dr. M. Subramaniam, sir, to honor the chief guest with the memento.
I request Dr. Shekhar sir to honor the guest. That will be very ideal. Sir, please.
Sir, please come center, sir.
Thank you all. To more about our guest speaker, Mr. Dinesh Kumar sir, I would like to invite Jeevita from first year MBA to talk about the guest speaker.
Good morning and warm welcome to all of you. Thank you for this opportunity to indeed an honor and a privilege to have Mr. P. Dinesh Kumar sir, an accomplished advocate as our chief guest today. Mr. Dinesh Kumar sir has a strong academic background in chemistry and law that is impressive. Academic journey includes a BSc in chemistry from NSS College, LLB from RGIL Kakinada, Andhra Pradesh, LLM from St. Christian College, Visakhapatnam, in addition to his academic achievements. Mr. Dinesh Kumar sir has a wealth of professional experience that he had worked in various capacities in the corporate sector. His expertise in the realms of original jurisdiction and writ jurisdiction makes him an invaluable asset to the legal community. We look forward to the insights and wisdom that Mr. Dinesh Kumar sir will share with us. Today, please join with me in extending a warm welcome to our chief guest.
Morning to one and all. Already they given a elaborate introduction about August person, Dr. M.S. Karthik sir, other August audience, and my beloved students. As Dr. M.S. sir told, I am a what you call busy practitioner. I am taking a caveat. Whenever there is an opportunity to interact with students and young people, I will take a first and foremost step towards that. As sir will be knowing it. Many times I used to travel to meet the students and interact with them. and I am waiting for an opportunity. The moment MSR and Karthik sir told about this, I never had a second thought. But I told that I am coming when I should come. Think of the same question that I asked you. When I should come to your institute. Everything comes second to me when it is a matter of academic interest. Because basically, for the past 5-6 years or 5-6-7 years, I am more associated with these students and all these things. Some of my students will be sitting here whom I traveled in American college with them. I think some of us are here. So they know about me. I used to come very early morning to American college. After that, I used to go to my court work. That is one part of it. Second, this Rlims, because it is piloted by a very eminent person. Because I don't know, I have to be doubly cautious while I am interacting in this forum. When a person of his stature, MS stature, is sitting here. Because it was a dream for me to become like him in IIM Yes, always. Even directly I told him, indirectly, Raja sir or many people would have interacted with them. Okay. So today the topic that we are going to discuss and we are going to demonstrate here is that we are creating a court sort of atmosphere. That is called moot court means a simulation of the court. Moot court means a simulation. How a person will draft an issue, how he will plead it, how he will convince him. These are the three parts of any case is concerned, as you know. So most of us would have, those who are studied in American college, I would have took one or two occasions to them to the High Court. So they know what is a High Court proceeding to some extent. One full day we spend there in the High Court to observe the court proceeding. It is foreign to the art students. Even for MBA students, it may be foreign to them. It may be an alien to you. It may be an alien to you. But I used to take them because even when I went there, many judges interacted with the students because everybody are very keen in interacting with the students because the ultimate thing is that every Indian, every citizen should know what is a court proceeding. Court is not something which is not accessible to the common public. What should be, we are in a welfare stage, we are not in police stage, we are in welfare stage. So accessible to the justice, accessible should be at your doorstep. That is the motto of Indian judicial system. That I need not to tell, and I don't want to take much time in elaborating about the judicial system, how Indian judicial system works. But one thing I like to tell you, the Honorable Supreme Court of India, the apex court of the largest democracy in the world, is ready to open by midnight 1:30 to discuss about an alien terrorist. That is the Indian judiciary. We may have a lot of drawbacks. We will be speaking people because of the Indian population and shortage of judges, shortage of courts, shortage of advocates. Everything plays an equal role. But our judicial system opened in midnight. You know that I don't want to elaborate what is the, because it may look sometime it may create a controversy. It is going in live also. But Indian judiciary are accessible to the people. You can knock the doors even at the midnight. They constituted a court. They heard as a last opportunity before they give a black warrant. That is the beauty of Indian judicial system. We proved that even though Indian judicial system, so your Indian constitution, as you know, even though it is adopted on 26 November 1949, Indian constitution has came into force on 26 January 1950. The Honorable Supreme Court also established on the same day. Even though we may be very young when comparing with the American Supreme Court or some other courts across the globe, but we are not second to none. Our judicial system, judicial activism has started, even based on the paper report, based on a postcard. A writ petition has been numbered in the Honorable Supreme Court, as well as the Honorable High Courts of various states. This speaks about the not only judicial activism, accessible to the justice to the common person. With this, I am going a little bit to the academic side. So, who are participating in the moot court proceeding today, sir? Then some of you can. Here. Just I will. Yeah. Okay. So before that, let them also hear what is that. Before you start the moot court proceeding, moot court is nothing but a court-like atmosphere. It is not a court. It is a simulation. How you create a simulator system. Simulation of a court. It cannot be demonstrated within a short time. But the basic things, how a court functions. For two things you will be approaching a court. Is it not? One is for a question of law. One is for a question of fact and another is for a question of. But most of the time, the issue will be mixed together. There will be a ingredient, one ingredient will be question of fact. Another ingredient will be question of law. Able to follow me? Two things only you will be approaching a judicial system. Is it not? One is for question of fact. Suppose this property, there is a dispute in the property. There is a disputing parties. One party claims that property belongs to A. Another gives another dispute that no, this property has been purchased by my grandfather some 70 years before. So this is the issue of facts. You understood? For this reason, you may approach our judiciary to decide the question of facts. Whether this person having the possession of that land, whether they belongs to him or it belongs to B. B tries to prove with the help of a documentary evidence. He is also giving documentary evidence. Additional to that, he is giving a possession. So there is a list as started. It is called list. One dispute has started. So one dispute has arose between two persons, namely A and B. They may approach the judicial system to resolve that issue. So here it is pure question of law. Question of law, the B claims to be that property with the help of a will executed by his grandfather. Then how his grandfather got that property? The grandfather got that property through a registered sale deed in some 1948. But that registered sale deed has been executed by a person who was not an absolute owner at that time. Then it comes to a question of law also. We have to prove the trustworthiness of that document. The document has to be tested. Court has to inspect that document. Because there are two proceedings in the normal subordinate judiciary is concerned, two processes are there. One is to question of fact and question of law, either question of fact alone or question of law alone or combination of question of fact and law. Most of the time, there will be a question of fact and question of law will be. It is inseparable. Very difficult to separate between these two. Okay. Then broadly it can be, the list means dispute. Dispute can be broadly divided into one category. One we common parlance we used to say civil type of dispute. Another parlance we used criminal dispute. In otherwise it is called criminal case. Civil dispute is concerned, it is purely related to the property, either disputing the property or the ownership of the property or the possession of the property or combined together. Or it will be for recovery of money. It is known as money suit. You will be knowing money suit you are filing. Suppose a person namely A accepted some money from B by executing a promissory note. Then he has not repaid the amount. He is approaching the court for recovery of money. So it is known as money suit. Oh, sorry, I forget to tell you. Civil cases is otherwise known as suit, and criminal cases is coming in the way of a petition or a complaint. Just I am giving a broader idea about how judicial system works. So when you approach a court for a civil dispute, either for a possession of a property or for an encroachment of a property or for or to prove the ownership of a property, you will be filing a suit. Common parlance, it is known as OS, original suit. OS, they would have numbered as a OS. Original suit means you are raising the issue at a lower judiciary at the first time regarding this matter. It is numbered as a OS. Suppose it is a criminal, some criminal activities are happening, or suppose you are subjected to some theft, your property has been taken away by somebody, or some bodily injury, somebody has hit you, some hurt has happened. It comes under the criminal jurisdiction. So civil jurisdiction, I already told you, this is a criminal side. Criminal side will be most of the time, it will be initiated in what manner? Normally what manner a criminal case will be? How you will start the criminal law into motion? Any idea? Those law graduates are there? Anybody who has studied law? No, nobody is here. It will be in the form of an FIR. A criminal law will be set into motion. anything, either bodily injury or loss of property, loss of life, loss of limb, everything happens, what you will do? What is the remedy? You have to file an FIR at the police station. First information report. That is, every Indian should know that. 154 CRPC, 154 CRPC. If you read any FIR, they would have mentioned Criminal Procedure Code 1973, 154, 154 CRPC. If criminal law has been set into motion, first way and best way to set into motion is by way of an FIR lodged before a station house officer. And there is one celebrated case law. Suppose you go and tell your police station, I was hit by somebody, or my property has been taken away, theft, or robbery, or dacoity has happened. By way of a FIR, you can start the criminal law into motion. It is purely the duty of the state. It is purely the duty of the state to take care the life and property of all citizens of India. It is assured by our Indian Constitution. Constitutional backup is there. So a police officer cannot deny filing an FIR if a cognizable offence has been taken place. No, offence can be broadly divided into cognizable and incognizable. Suppose you are rented out a house to somebody, that man is not vacating. You cannot go to police station. Legally, you cannot go to police station because it is a non-cognizable offence. Only cognizable offence you can go to police station. Okay. Once a cognizable offence has been reported, once a cognizable offence has been committed, you can report to the nearest police station or you can report over a phone. That option is there. 154 CRPC says, they read like that. If at all you have a CRPC book, you can take 154. It would have mentioned either orally or in written form. Either orally or in written form. CRPC 154 doesn't say you have to file a written petition. You can go, you can tell the station house officer has to reduce it to writing, he has to enter in the register and make an FIR. This is a legal position about FIR. What the Honorable Supreme Court says in Lalita Kumari versus Government of Uttar Pradesh or State of Uttar Pradesh, 2004 case. 2004 case, what the Honorable Supreme Court says is that if a cognizable offence has been reported to a police officer has no option. He has to register an FIR. Immediately, he has to register an FIR. But there is an exception for 3 categories of cases. Investigation is an exclusive province of a police. But in Lalita Kumari case, they given one liberty to the police officer to conduct an inquiry, inquiry, in 3 types of cases. That is, preliminary inquiry he can make in matrimonial issue. Suppose a matrimonial matter is reported, any matrimonial issue, either violence or some dowry harassment, something is reported to a police officer. Police officer can conduct a preliminary inquiry. Second, if it is a medical negligence, he need not register immediately FIR. He can wait, he can conduct a preliminary inquiry. And third, commercial transaction, which is your, suppose I say Subramanian sir, as I given some check to him, sir is not supplied the goods, the police officer will not immediately make an FIR. He will call the so-called accused person, he will conduct an inquiry. Inquiries and third, commercial transaction. And fourth one is delay or latches in reporting criminal cases. Suppose I say in 2002, somebody has hit me, somebody has kidnapped me, somebody has abducted me. Suppose I say, it is not fatal to a criminal case. Delay is not fatal, but unexplained delay is always fatal. These 3 categories of cases, police officer, so Honorable Supreme Court has given a power for the police officer to conduct a preliminary inquiry. Otherwise, inquiry is alien to police officer. Police officer can conduct only investigation. But they will say, we are calling you for inquiry. That is legally, that is not correct. So a criminal motion can be set into, you can set into motion by way of, criminal law can be set into motion by way of registering an FIR. Then ideally speaking, and second thing I forget to tell you, because the Sushant Rajput, I think his name, that film actor in Bombay, I saw a TV news, it was shocking to me. DC, Deputy Commissioner of Police of Bombay, his father, some press reporters were asking him, Sir, they say this Rajput's murder, there is one doubt, his death, some suspicious death. So his father says there is some doubt in that. So immediately that DCP, Deputy Commissioner of Police, says, let him give it in writing. If somebody is give it in writing, I will investigate the matter. What is the need? 154 CRPC, what it reads? Either orally or written. He has to, if it is given in orally, he has to reduce into writing and obtain a signature from the person who makes the first information. So there is no need to write. So the IPS officer, young IPS officer, awareness has not been created by the, everything when you go to police station, they will say, you give it in writing. Correct? They will give you, you would have some of our friends either vehicle theft or some theft happened in the house. So nearby something has happened. Let them give it in writing, they will say. Need not. CRPC doesn't say writing. Second thing, he cannot refuse FIR. Registering an FIR, other than these 4 cases which I told you, 4 category of cases, police officer cannot deny or he cannot refuse to register an FIR. Even the Lalita Kumari says, Lalita Kumari versus State of Uttar Pradesh, 6 judges decision, division bench, constitutional bench decision. Departmental action has to be initiated against the police officer if he is failed to comply with the Supreme Court order. And that has to be circulated to all police officers and all police academy, it has to be mandatorily taught. That is what the Honorable Supreme Court standing in the case of FIR is concerned. And another thing is that to give a first information, according to this is also Supreme Court finding, you need not be a victim or witness even. You need not be a victim, mark these words, you need not be a victim or not even a witness. Suppose I am going, somebody says, a man is dying in a pool, man is laying in a pool of blood. So police officer cannot say, have you witnessed it? No, I heard so. I heard so I informed you. It is up to you to find out whether who has killed him, or who has stabbed him and all this thing. It is your investigation skill that matters. This is the criminal case is concerned. There is one more way, all persons should know, especially management graduates should know, there is one more way of getting criminal law into motion. Anybody, any idea those? Other than FIR also you can initiate the criminal, you can prosecute somebody. There is one more method is there in CRPC, which is there in 200 CRPC. 200 CRPC say private complaint. Private complaint. You can straight away go to magistrate and file a complaint before the magistrate. I came here because I suffered such and such situation. You may take up the cognizance of this case. And I have all the evidence with me. I am ready to provide you the evidence. You take up this case. That is popularly known as private complaint. That is also one of the way of taking cognizance by the magistrate. Concerned magistrate, jurisdictional magistrate, he can go. 200 CRPC speaks about the private complaint. Normally, you know, FIR can be lodged by only by police officer. Suppose you are all studying somebody marine engineering and somebody was introduced by somebody. Suppose a customs officer, he cannot file a FIR. What he will do, he will make a complaint to the magistrate. That is called complaint. Customs officer seizes a gold here, or contraband here, narcotics here. Well, narcotics, of course, comes under the police wing. He will file a private complaint only. Before the magistrate, he will file a complaint. And this is also one of the way of setting criminal law into motion. So this is about, one is about civil side, another is about criminal side. There is one more jurisdiction, which is an exclusive jurisdiction of Honorable High Court as well as Honorable Supreme Court. Anybody can tell that? To attract your attention, I am asking question. Otherwise, it will become a side talk. Writ jurisdiction. Have you ever heard about the writ? Writ jurisdiction. Because most of the people say, I filed a writ in the High Court. It is an exclusive, original jurisdiction of Honorable High Court and Honorable Supreme Court. Subordinate judiciary doesn't have a writ jurisdiction. What is writ? Any idea about writ? I think it's some legal subject you are studying. Constitution is there in your subject. Writ jurisdiction, especially there are 5 types of writs are there. Most of you will be knowing. One is called habeas corpus. Second is called mandamus. Third is called prohibition. Fourth is called certiorari. Fifth is called quo warranto. 5 types of writs are there. Most of you will be familiar with the habeas corpus writ. Habeas corpus writ, most of you will be familiar with the habeas corpus writ. Habeas corpus writ is, sir, suppose a person has been arrested by a police, or suppose man missing, you are complaining to him, you went to the police station, no remedy, so you can file a habeas corpus under Article 32 in Honorable Supreme Court, under Article 226 in Honorable High Court. Both are having co-equal jurisdictions are there. High Court also can take cognizance. You need not travel all the way to Supreme Court. So this habeas corpus writ is that habeas corpus means have the body. So they will be forced to, police officer will be forced to produce the person who is missing before the court. Practically most of the time the habeas corpus writ is, we will invoke the Article 226 in the High Courts, mainly when there is some bodies would have taken, especially Gundas Act. When they are arrested in Gundas Act, we will file a writ under habeas corpus. Even one of our, I don't want to tell the name, a celebrated minister has been arrested. His wife filed a habeas corpus. And there was a difference of, there was no identity of crime among the judges. Division bench, one honorable judge told it is this arrest is illegal, so he has to be released immediately. Another learned judge told, no, he has been produced before the magistrate. Whereabouts are known, his wife has visited, even Human Rights Commission has visited him, so habeas corpus will not stand. So when there is a split in the bench, our Honorable Chief Justice constituted another bench of the learned opinion that, considered opinion that habeas corpus will not stand in this particular case because his whereabouts are well known. When your whereabouts are well known, where is the question of habeas corpus? It is purely an abuse of process of law. That is called the writ jurisdiction, which is an original jurisdiction of High Courts and Supreme Court. Because you know, this Honorable Supreme Court top is one of the top court in India. It has an original jurisdiction, it has an appellate jurisdiction, it has a writ jurisdiction, and it has an advisory jurisdiction. Advisory jurisdiction also is there when our His Excellency President come across with any conflict of law, immediately he may refer. For example, Indri Berubari case, in reference to Berubari case, very celebrated case, immediately after the independence, the first President of India has referred to the full bench of the Supreme Court. They decided. Advisory, they not decided, they will advise on His Excellency President of India. His Excellency President of India. And the High Court also has got these all co-equal powers of Supreme Court except advisory jurisdiction. That is original jurisdiction is there. Original jurisdiction by way of writ petitions. And also original suit. Second thing, appellate jurisdiction, of course, first appeal, second appeal they have. And these are all the jurisdiction of Honorable High Court. So here, and this is the court structure you will be know in India. Most of you, I think you are familiar with how the judicial system, topmost court is Supreme Court. Supreme Court is headed by Chief Justice of India. It's not only a Chief Justice for Supreme Court. Now Chief Justice of India is Honorable Justice, our beloved Honorable Justice Chandrachud. And he has been, there is a plethora of honorable judges to help him. And below that there is High Court for each and every state, or for one or more state there may be High Court. The state where we are now, Madras High Court. Madras High Court is now, both for Pondicherry as for Tamil Nadu, is the territorial jurisdiction of Madras High Court. It is one of the oldest High Courts, second oldest High Court in India, and one of the oldest High Court in the world. It is older than Honorable Supreme Court. Madras High Court is older than Supreme. You will be knowing that East India Company in 1600 December 31st, when Royal Charter has been issued by the Queen Elizabeth, and East India Company has landed in India to do business activity in India. From there only, the origin of judicial system started in India. Then also it took a lot of time. In 1860 only there was Indian Penal Code has been casted by Lord Macaulay by sitting in Udagamandalam, Ooty. He brought the Indian Penal Code 1860, which is the criminal law even now. Indian Penal Code 1860. Indian Evidence Act has been casted by Lord Stephen, because all this legal system we can trace back the history in the England. Bloodlines can be traced in England. And now, when come to the another important aspect of just I am skipping many things because of the scarcity of time. And there is something called court craft. Something called court craft. What do you mean by court craft? Court craft is nothing but how you will interact with the court, how you will make a submission before the court, how you will convince the court, how you will address the court, how the court will address you. There are certain, even now, we follow the colonial system in the judicial system. Post-independent era, even full court, I think in 61 or 62, our Honorable Supreme Court, full bench has made a unanimous decision that in future you need not address us as my lady or my lord or my lady. You can address Honorable Justice, or you can address Your Honor, Honorable Court, or you can address Mr. Justice, because V.R. Krishnayer was one of the proponents of Mr. Justice system. He says you can call Mr. Justice. Why should you call Lordship? It was a previous colonial, my lord or my lordship or my lady. Why should you address? But in my very minimal experience or my limited experience, yes, still we follow lordship or my lady, my lord or your lordship only we address. And subordinate courts also, many advocates address them as a lords or my lordship, my lord or my lordship, or at least honorable court. Nobody likes to, they say you address us as sir, but practical situation is different. And this is one side of it. Court craft is concerned, you have to, your everything plays a role, including the etiquette, because I was particularly asked, Subramanian sir will be knowing what should be my this thing. So you should say, you come as if you go to court. So that is very important. I will tell you, one municipal court, they won't allow you to speak without, you cannot represent without having the dress code. Dress code is very important for advocate is concerned. I don't know about the NCLT. When you companies or people goes, they are going with the normal dress, formal dress only. But when advocate goes, they will go with this. Because Advocate Act 1961 says when advocate, whenever you are representing, you should go in this. This is the etiquette that you have to have. That is a must. Otherwise, there may be some other repercussion will be very severe. Yes, that is a non-fact. Jeans, t-shirt and all is it is. See, when you are going to, there also quasi-judicial body. Yes, and also I want to touch upon that. Before, let me complete that court craft. Court craft is applicable to both judicial as well as quasi-judicial. Quasi-judicial also judicial only, maybe particular matter. Company, National Company Law Tribunal deals with the company matters, but they are also quasi-judicial body. Quasi, Q-U-A-S-I, quasi-judicial body. Okay. Court craft, you say, I suggest you always you address my lord or your lordship or my lady, depending on the gender who is sitting there. So that it will not invite the anguish. It will not invite the anguish of that person. Because, and second thing, whenever you are addressing a court, you have to address straight to the court. You should not turn back, take some file or something like that. When you are going also, you have to go a little back, then you have to turn. Immediately you should not turn. And it is a customary in judicial system that always it should be even small things. Even if your case is dismissed, they will say much obliged. I don't know the system. And also when you are called to present your case, right from top man, maybe Mr. K.K. Venugopal to the down Dinesh Kumar, he will always, may I please my lord. Because it is a formal talk in British, you know, this in English system, that you will seek a permission before you speak. So most of the time, you know, if you would have gone to the court, they will say, may I please my lord, your name has been called, your number has been called, again you will see, may I please my lord. They will say, yes, please. They will nod their head, yes, please, go ahead. Or sometimes, why? Because sometimes you may be reading something, you are fine. You may be reading your style. In the meantime, if you start speaking, it may divert his attention. So that is why we seek the permission of a court before we present our case. So the people who are participating in the mute court, you may keep it all this thing in your mind. Yes, so you are all participating in this one. How many people? How many people? 5. Both are different people. One maybe who is representing the petitioner, another is representing the. You will be one. Okay, please sit down. Please sit down. Please sit down. Just a minute, because I thought of addressing you for this specific matter. And second thing, you should form the issue in such a way that it should be in this. First, you should IRAC method, we used to say, issue rule analysis, and finally prayer. First, you write your issue. What is your issue? You present it. You speak your issue. This is the issue. This is the issue. That is purely facts. No law is needed. No law is needed in the play. First, it is only issue. How the cause of action. How the cause of action arose. When the cause of action arose. What is your right? Where it is infringed. Where your right has been infringed. You may have some inherent right. That is why you are coming to the court. That right has been infringed or taken away. That is what your grievance is. So you have to elaborate it. When it started, infringement has started, what way it affected you, what is the question of law. What the old British Parliament's school of thought is that you tell the fact, we will decide the law. That was the previous concept. But the emergence of Indian judicial system, now we say, both the infringement of rights as well as infringement of law has to be there in the plaint or in the petition. I think you will be knowing the difference between plaint and the petition. Plaint is purely civil in nature. If there is an element of criminal nature, it will come as a petition. That is called OP, original petition. OS is called original suit. WP is called writ petition. That is the way the practically court system we operate. Appeal suit is known as AS. That is AS, the number start with AS, you can assume and you can presume that it is an appeal suit. It is not an original suit. Already he has sought a remedy under lower court. He has not aggrieved by the order of the lower court. You are coming here with an appeal suit. That is AS. SA means second appeal. Even first appeal you are not happy. You are aggrieved by the order, you are coming. So, the issue should be there, where the facts should be clearly mentioned in the plaint or petition, and there should be infringement, where you are infringement, what is the question of law. That has to be clearly elaborated. And how you are going to prove your case. That is more important in judicial system. It can be proved with 2 things. A case can be proved with the help of 2 things. One is an oral evidence, second is a documentary evidence. Both are acceptable. Now, one more evidence is acceptable under Amendment of Indian Evidence Act, Section 65 capital B, that is electronic evidence. Now, electronic evidence also is acceptable. CCTV footage, telephone talk, recorded telephone calls, and any number of electronic evidence. Many times, we are on a mobile phone, that is a portable computer, we can say. You can record the settlements. We can see the social film, this viral clippings. Police person, when he catches or he snatches the key, immediately you will take a virus, this telephone and this mobile phone and recording it, and you can put it in the. This can be marked as an evidence before a court. Previously, it was not acceptable. Now, Section 65B, Section 65, there is one more amendment that took place. All electronic evidence which is accepted by the court or which is subject to the inspection of the court will be marked as an electronic evidence. Nowadays, most of the criminal cases has been proved with the help of electronic evidence. So it is also one of the very good quality of evidence is very good in case of electronic evidence. These are all the 3 types of evidence you can find. What is oral evidence? A person come to the court and response statement under an oath. If he make a statement, it is an oral evidence. And oral evidence can be rebutted by a documentary evidence. So which is more stronger among the evidence, oral evidence or documentary evidence? Of course, documentary evidence is stronger, but the test of the document is that test can be laid about the trustworthiness of that document. Whether the document has been fabricated one or you created some document, all these things can be tested. And evidence also can be given two types of evidence. One is called primary evidence, another is called secondary evidence. Suppose I got some amount from Subramanian sir, some 10,000 rupees. I executed a promissory note. Subramanian sir produces a promissory note, original promissory note, before the municipal court, saying that, see, I am marking this as an evidence. This fellow got 10,000 rupees from me on such and such date at our age. This is the evidence that I am using. This is called primary evidence because he is giving us an original copy. If it is photocopied one, if it is electronically manipulated one, that is Xerox copy, normally we used to say, that is called secondary evidence. Secondary evidence normally court will not accept. But two occasions the court may accept. One, the promissory note will be with the other side. To make him to bring that promissory note, I am marking secondary document. See, what I have done, I wrote a promissory note, shown him, given a Xerox copy and kept it with him. Or another thing. So he is marking a promissory note. So to disprove it, I have to produce another promissory note, saying that he has manipulated. I got only 10,000 rupees. He added one more zero and took a Xerox. See, this is the original one. So that document, secondary document, can be rebutted by way of a primary document. See, primary document has been rebutted. Then one more thing is there. Primary document, secondary document can be marked if within reasonable expenses you cannot get the primary document. Certain documents would have been burned in the fire. So other side also, judicial notice also can be taken. It is around this executed in 1881. That has been due to natural this thing, it has been spoiled. So but I have a secondary document. So the secondary document can be relied upon by the court. It is a discretion of a court. Purely it is a discretion whether to accept a secondary document, but it has to be corroborated once. It can be corroborated. And another thing that I want to touch upon is that everybody should know. Regarding two things I like to touch upon, whether I have a time, sir, or time is already, it's nearing, time is, shortage of time is there. 2 minutes. 2 minutes. 2 minutes I can tell you only one thing. Only one, which is very important for all Indians. Suppose you have been taken by a police on some suspicion, anybody, with God's grace, nobody should have that. Police person asking you to confess, you tell him, you give it in writing, I killed that person, I swindled that money. Otherwise, you will be put under physical torture, mental torture. You will be put under, otherwise, police has their own way of extracting truth and confession statements. Popularly, it is known as confession statement. Oppudal Vakumolam, Tamil, confession statement. Suppose they get a confession statement, whether it has any validity before the court. Confession statement you would have obtained under duress. It would have been obtained under duress. You will be put under torture or somebody else. If you doesn't make a confession statement, your parents will be in my custody. I know. Get it. Police inspector will say. But I will tell you from my experience in having dealt with both sides, confession statement has no legal sanctity. Because of the section 25 and 26 of the Indian Evidence Act and section 162 of the CRPC, you can boldly give a statement to a police officer. It cannot be marked as an evidence against you. It cannot be marked. Confession statement given before a police officer cannot be marked. Confession statement obtained under threat, inducement and promise cannot be marked. This is the basic criminal system. Because what is the true doctrines in criminal jurisprudence? One is beyond reasonable doubt. Second is presumption of innocence. With this, we will move to okay.
Thank you, sir, for your valuable speech about the
Now, let's start about the debate session. I would like to welcome our team members of first year MBA, Sridhar, Ponkumaran.
Thank you, sir. Now the session is going to start. Moot court. The case taken here is the bonus issue. Normally companies பார்த்தீங்கன்னா இப்போ நம்மளுக்கு தீபாவளி போனஸ் கொடுப்பாங்க. ஸோ போனஸ் இஷ்யூ தான் இப்போ எடுத்துருக்கோம் நாங்கள் கேஸில். இந்த கேஸ் எப்படி அப்படின்னா கார்பரேட் சைட் போனஸ் கொடுக்க மாட்டேன்னு சொல்லிட்டாங்க கம்பெனி. திஸ் இயர் வி ஆர் நாட் கோயிங் டு கிவ் போனஸ் அப்படின்னு சொல்லிட்டாங்க. ஸோ அது வாதாடுறது ஸ்டூடெண்ட் சொல்லுவாங்க. தி யூனியன் சைட் எங்களுக்கு போனஸ் வேணும் அப்படின்னு சொல்லி அவங்க 2 பேர் வாதாடுறாங்க. ஸோ இதுதான் அந்த கேஸ் பற்றி. ஸோ போனஸ் இஷ்யூ. ஸோ கம்பெனி சைட்லேருந்து வாதாடுறதுக்கு ஐ இன்வைட் தீபிகா அண்ட் பொல்கமன் ஸ்டேஜ். So they are from the corporate. So union side la vaadadukku Kritika, Divyadarshini and Sridhar. The session is on now. So from the union side, Divyadarshini, Kritika and Sridhar. So from the corporate, Kumar and Deepika. They are going to present their case. On the bonus issue discuss panavara. Let us begin. The session is on.
In our company, the cost of production varies. We are a sugar industry company. For our main raw material for us is sugar cane. In this year, the sugar cane reason were very bonus வந்து கொடுக்கல அப்படின்ற மாதிரி நாங்க வந்து சொல்றோம்.
May I please, sir?
Yes, please.
Sir, I object their view, sir, because they are saying that cost of production has been increased in the industry, sir. After COVID, cost of living also increased for our family, sir. For example, if a person earn 100 rupees in 2005, they will save at least rupees 20 and spend rupees 80 for their family, sir. In 2020, savings reduced by rupees, so increased to 1,100, and also education structure in a fee structure also increases, sir. So we are saying that our cost of living also increased, so we are planning some expenses with the bonus. So we are expecting.
You received increment in your wages, is it not? How much you received increment? Yearly increment you received?
Sir, we have not received.
A2.
You may have some index, Bombay index, Simla index. So you would have calculated increment. Have you calculated increment in that?
No, sir. Not to give a salary for increment.
You are not increased.
No, sir.
Salary கொடுத்தீங்களா increase
இல்ல கொடுக்கறேன் நான். இன்னும் நாங்க வந்து salary நாம increment பண்ணல.
எத்தனை வருஷமா கொடுக்கல increment?
2 years ஆதா சார். இப்போ லாஸ்ட் ஒரு 2 or 3 years மட்டும் தான்.
திமிகா சொல்லுங்க எத்தனை வருஷம்?
1 year once வந்து நாங்க இன்கிரிமெண்ட் எப்பவுமே கொடுப்போம் சார். நான் இப்போ வந்து லாஸ்ட் 4 இயர் கம்பெனி ஸ்டார்ட் ஆகி 4 இயர்ஸ் ஆச்சு சார். லாஸ்ட் 4 இயர்ஸ் எங்களுக்கு லாஸ் பண்ணாலும் சரி ப்ராஃபிட் வந்தாலும் சரி நாங்கள் வந்து இன்க்ரிமெண்ட் கரெக்டாக வந்து ப்ரொவைட் பண்ணிட்டு தான் சார் இருந்தோம். இந்த இயர் தான் எங்களால் வந்து
How you calculate the increment?
அப்போ ஒரு சில ஒர்க்கருக்கு வந்து ஸ்பெசிஃபிக்கா இவனோட பெர்ஃபார்மன்ஸ் எப்படி இருக்கு அந்த ஒவ்வொரு ஒர்க்கர்ஸ்க்குமே வந்து ஸ்பெசிஃபிக்கா பார்த்தா சார் நாங்க இன்கிரிமெண்ட் கொடுக்கலாம் அப்படின்ற மாதிரி பிளான் பண்ணிருக்கோம் சார். அப்படிதான் கொடுத்துட்டு இருக்கோம்.
So pay for the performance.
Yes, sir.
You follow the strategy or pay for the performance.
Yes, sir.
Based on the performance you are paying.
Yes, sir.
You want to say something?
டார்கெட் கரெக்டாக கம்ப்ளீட் பண்ணுறது அந்த பிஹேவியர் பொறுத்தும் அந்த பெர்ஃபார்மன்ஸ் பொறுத்தும்
that is what I am telling you. You are paying for the performance being more. So what will be, can you quantify what will be the maximum?
20.
For bonus first, but our learned friend Divya, Kritika told that for inflation to cope up with the price raise, she want more. So there is some contradiction, I feel.
Sir, actually they are not giving any.
What is your clear need?
Sir, actually they are not giving any bonus. We expect bonus from them, sir.
The bonus is only your issue.
Yes, sir.
Wage revision is not your issue.
No, only bonus, sir. Yes, sir.
So what is your demand? Have you given COD, charter of demands to them? Have you submitted COD? Have you received from them? Given in writing? COD has not been given. Then how will it be knowing? They are ready to give. But you are not. Yes. They are not. You are not asking. Without asking, how you will give? There is something called charter of demands. COD. Union would have submitted. So you submit it so that pass order accordingly. You tell me what is your need. How much you need, you have to inform them.
Sir, we need 20% discount.
Sir, how you will be known to me? You are the person who is your management. Have you informed your management that I need 30% or 20%, whatever it is? Then only we can bring him for a negotiation or negotiated settlement of the bonus issue. So you give COD. Presume that first you give him your need. Then we will have a discussion. That has to be filed along with the petition. When a dispute is raised, there is no industrial dispute now. Time being, no industrial dispute according to me. Because you think that you need bonus. You think only, no, you are not asked about it.
No, sir, we have asked 20% of bonus from them and they are
He
denying.
says you are not asked, now you...
No, we have asked bonus, they are
submit the
denying to
papers.
give, sir.
You submit the papers, you demand what is your need.
Expenses அதிகமா இருக்கு.
Sridhar, they say 12%.
Sir, 10 to 12%, you will be ready to give for your bonus. What do you want?
12% immediately you give us a cash, along with salary.
But 12% is very low. 12 is ரொம்ப கம்மியா தான் இருக்கு. 20% நீங்க கொடுங்க. அதுதான் நாங்க உங்களோட மெயின் பாயிண்டா நம்ம உங்ககிட்ட கேட்கறது. அதுவும் இல்லை இப்போ உங்களுக்கு 12ன்றது இண்டிவிஜுவலோட எங்களோட ஒரு தனிப்பட்ட முடிவு கிடையாது. எங்களோட ஷேர் ஹோல்டர்ஸ் அவங்களுக்கு போக எல்லாத்தையும் டிஸ்கஸ் பண்ணி தான் உங்ககிட்ட நான் வந்து சொல்றேன் இந்த பர்சன்டேஜ். எப்பயுமே வந்து இப்போ இந்த 12%ன்றது உங்ககிட்ட இப்போ கரெக்டாக நாங்கள் சொல்றது கிடையாது. ஆல்ரெடி உங்களுக்கு 4 இயரே வந்து நாங்கள் உங்களுக்கு
எம்ப்ளாயிஸ் மோட்டிவேட் ஆகி உங்களுக்கு இன்னும் டர்ன் ஓவர் இன்க்ரீஸ் ஆகணுன்றதுக்காக தான். இப்போ நீங்கள் வந்து போனஸ் வந்து கம்மியாகவே சொல்லிட்டே இருந்தீங்கன்னா அஃப்கோர்ஸ் எம்ப்ளாயிஸ் வில் டிமோட்டிவேட் அண்ட் யுவர் கம்பெனிஸ் டர்ன் ஓவர் வில் கெட் ரெடியூஸ்ட்.
இப்போ இந்த நம்மளோட லெவல் எவ்வளோ முதல்ல தெரிஞ்சுக்கணும். இப்போ வந்து நீங்கள் போனஸ் கேட்குறது பிரச்சனை இல்லை, 20% கொடுக்குறது நாங்கள் ரெடி தான். ஆனால் கம்பெனியோடைய ப்ராஃபிட் லெவல் கம்மியாக இருக்குன்னு சொல்கிறோம். இப்போ டிரான்ஸ்போர்ட்டேஷன்ஸ் அதிகமாகிடுச்சு, ஃபியூல் எல்லாமே வந்து கூடி போச்சு, மக்கள்கிட்ட ஒரு அவேர்னஸ் கிடையாது. ஏன்னா நம்மளுடைய டிரான்ஸ்போர்ட்டேஷன்ஸும் கொண்டு போய் வைக்கக்கூடிய ரா மெட்டீரியல் எல்லாமே நமக்கு வந்து இன்க்ரீஸ் ஆனதுனால நம்மளுடைய ப்ரைஸையும் நம்ம என்ன பண்ண வேண்டியது, இன்க்ரீஸ் பண்ண வேண்டியது இருக்குது. அப்படி இன்க்ரீஸ் பண்ணுறதுனால நம்ம ப்ராடக்ட் மேலே இருக்கக்கூடிய அவேர்னஸ் போயிடுது. அப்போது நமக்கு எங்கே நமக்கு ரா மெட்டீரியல் வருதோ அங்கே வந்து அது ப்ரைஸ் வந்து கம்மியாக கிடைக்கிறதுனால மக்கள் எல்லாமே அங்கே போயிடுவாங்க. பட் நம்மளோட ப்ராடக்ட்டை இங்கே வாங்குறதுக்கு ஆள் இருக்க மாட்டாங்க. ஸோ நாங்கள் என்ன சொல்ல வரேன்னா, இந்த வருஷம் நாங்கள் கொடுக்க முடியாதுன்னு சொல்லலை, இந்த வருஷம் கம்மியாக வாங்கிக்கோங்க,
போனஸ் வேணும் அப்படின்னு சொல்லிட்டு நாங்கள் கேட்குறோம் சார்.
Union is for both the sales, marketing as well as for production, is it not? There is separate unions are there? Or no? There are separate unions are there? Trade unions are separate, registered, recognized trade unions are there. It is totally 81 union is there. You are representing you are representing marketing, production, total trade unions.
Sir,
total employees.
அவங்க கம்பெனி வச்சுருக்காங்க, நாங்கள் வந்து லேபர்ஸ் வச்சுருக்கோம். ஸோ வந்து எங்கள் பாயிண்ட் ஆஃப் வியூலாம் கரெக்டாக இருக்குன்னு தான் சொல்லுவோம். ப்ரொடக்ஷன் யூனிட்ஸை வச்சு கரெக்டாக போகுது. அதுக்கு நாங்கள் ஒரு யூனியனாக பேசுகிறதுனால வந்து ப்ரொடக்ஷன் யூனிட்டு இதுக்குள்ளே வரும் தான் சொல்லுவோம்.
That is okay. Now you need 20%.
Yes, sir.
So I have a doubt. How you arrive at this 20%? Why not 30%? Why not 10%? And why this magic number 20? How you arrive at this magic number 20? Any specific reason or you thought it is?
Explain, sir.
Discuss that. Yes, please.
சார் we are taking basic on rough basic only. நாங்கள் எம்ப்ளாயிஸ் கேட்டதில் வந்து அவங்க வந்து ஒரு 20% இருந்தால் ஓகே, இந்த இயருக்கு வந்து கன்வீனியண்ட்டாக இருக்கும்னு கேட்குறாங்க. ஸோ அந்த சார்பில் நாங்கள் வந்து 20% வச்சு எங்களுக்கு கேட்குறோம் சார்.
It is a unanimous decision in the union, general body meeting.
ஸோ இப்போ மேனேஜ்மெண்ட் சைடுமே சொல்கிறாங்களே சார், அவங்களுக்கு இப்போ நிறைய எக்ஸ்பென்சஸ் அதிகமாக இருக்குன்னு சொல்லி. ஸோ நாங்கள் ஹையாக போட் பண்ணோம்னா அவங்களால கொடுக்க அந்தளவுக்கு வராதுன்னு சொல்லி, ஸோ நாங்கள் வந்து நாங்களுமே ஓகே 20% ஆச்சு இருந்தாலும் ஓகேவா இருக்கும் அப்படின்னு சொல்லி கேட்குறோம் சார். எம்ப்ளாயிஸ் எல்லாம் சேர்ந்து
Legally, what is your entitlement percentage?
மினிமம் லீகலாக 8.33% வரணும் சார்.
For 20%.
எஸ் சார்.
எங்கிட்ட வந்து ப்ரொடக்ஷன் எல்லாமே பிரச்சனை இல்லை சார். ப்ராடக்ட்டில் வந்து குவாலிட்டி குவான்டிட்டி எல்லாமே கரெக்டாக தான் சார் இருக்குது. ஏன்னா எங்ககிட்ட ப்ரொடக்ஷன் இருந்தாலும் சேல்ஸ் அந்தளவுக்கு இல்லை சார். சேல்ஸ் இல்லை, ரெவன்யூ வந்தால் தான் சார் நம்ம போனஸ் கொடுக்க முடியும். ப்ராஃபிட்டே லோவாக இருக்கும் போது நம்ம 20% எப்படி சார் கேட்க முடியும் நம்மக்கிட்ட? தட்ஸ் மை பாயிண்ட் சார்.
Yes. Founder, what do you say? See, my view is that they say they have their own problems, financial problems and business. They have their own financial problems and management issues. And you are also part of it. And legal entitlement is far below. Legal entitlement is far below than your demand. Legal entitlement is far below. They are not told, but this is my observation. Second thing, they told it is incorporated only 4 years before. So what the Bonus Act says?
சார் 5 இயர்ஸ் வரைக்கும் அவங்க கம்பல்சரியாக போனஸ் கொடுக்கணும் சார். ப்ராஃபிட் வந்தாலோ வரலையோ அவங்க வந்து 5 இயர்ஸ் வரைக்கும் கம்பல்சரியாக
5 years?
இன்கார்பரேட் ஆகி 5 இயர்ஸ் சார்.
Clarify. What they say is right, I don't. According to my knowledge, you may refer Bonus Act. You may refer Bonus Act. Up to 5 years, they need not. I am not contributing it. It is off the record. But again, they are magnanimous to offering 12%. Well, we can further negotiation is possible. Can you ready to can you go up a little bit? Because they say they are also your people. Part of you. They are part of you.
Sir, 12%
They are not outsiders. They are your people.
Sir, 12% என்றது,
No, that you clarified it. Because your people are asking for 20% because they too have their own day-to-day expenses are going up. So can you go a little bit?
sir, அதுல 12% போகவே அவங்களுக்கு வந்து food செலவு, அவங்களோட
Well,
transport
that we are discussing only bonus matter now. We are not discussing it. Can you go up a little bit and can you come down a little bit so that we can settle the matter? Don't stick on to
சார் ரெண்டு பேருக்குமே வின்வினாக தான் சார் இருக்கணும். நாங்கள் லாஸை வச்சுக்கிட்டு உங்களுக்கு கொடுக்க முடியாதுல்ல சார். அவங்களுக்கும் வின்வினாக இருக்கணும், எங்களுக்கும் வின்வினாக இருக்கணும். போத்தா சேமாக இருக்கணும். எங்களுக்கே இங்கே லாஸ் இருக்கும்போது நாங்கள் உங்களுக்கு கொடுத்துட்டு இப்போ இன்னொரு லாஸ் ஆச்சு அப்படின்னா ஃபியூச்சர் ஏதாவது ஒன்று கம்பெனிக்கு ஆயிடுச்சு, ஃபயர் ஒர்க் ஆயிடுச்சு, ஏதோ ஒன்று ஆயிடுச்சு அப்படின்னா நாங்கள் எங்கே போகிறது? நாங்கள் உங்களுக்கு எடுத்து வச்சிருக்கிற ப்ராஃபிட்ல இருந்து ரிசர்வ் வந்து உங்களுக்கு எடுத்து கொடுக்க போகிறோம் நம்ம உங்களுடைய போனஸ். ஸோ அப்படி கொடுக்கும்போது நாங்கள் அதிகப்படி உங்களுக்கு கொடுத்துட்டோம் அப்படின்னா ஃபைனல் இயர்ஸ், அதாவது அடுத்து வரக்கூடிய இயர்ஸில் வந்து ஏதாவது ஒன்று கம்பெனிக்கு ஆயிடுச்சுன்னா நாங்கள் என்ன பண்ண சார், என்ன சார் பண்ண முடியும்? வின்வினாக தான் இருக்கணும் அப்படின்ற மாதிரி என்னோட பாயிண்ட் நான் முடிக்கிறேன்.
what they say is that suppose they will beg for or steal something and give to you. Tomorrow if the company go for retrenchment or closure, what will happen to your job? Only if the organization should survive, company should survive, then only your survival is directly depends upon their survival. Not that you are separate and they are, you all are a part of a system. Only your problem is this 8%. You are asking for 20. They are ready to give 12%. They are ready to give 12%. Maybe some ex gratia after 2 months if it is suggestion of a court. Court suggests. No, not now. After some ex gratia amount, can you give some ex gratia? They are willing. Then we can sign and seal now itself.
சார் ஆக்சுவலி வந்து அவங்க 20% வரதுக்கு ரெடியாக இல்லை. நாங்கள் என்னெல்லாம் சொல்கிறோம் அப்படின்னா, இப்போது இதே மாதிரி கம்மியாகவே அவங்க பிட் பண்ணிகிட்டே இருந்தாங்க அப்படின்னா மேபி எம்ப்ளாயீஸ் வந்து ரீலோகேட் ஆகிறதுக்கு வாய்ப்பு இருக்குது. அதனால அவங்களுக்கு தான் ரீப்ளேஸ்மெண்ட் காஸ்ட் வந்து இன்னும் கொஞ்சம் அவங்களுக்கு இன்க்ரீஸ் ஆகும். அந்த மாதிரி ரீப்ளேஸ்மெண்ட் காஸ்ட் இன்க்ரூவ் பண்ணுறதுக்கு பதிலாக அதை எங்களுக்கே போனஸாக கொடுக்கலாம் அப்படின்னு நாங்கள் எதிர்பார்க்குறோங்க. இன்னும் வந்து இஃப் சப்போஸ் அவங்க டெக்னாலஜி டெவலப் பண்ணியோ இல்லை புதுசாக ஏதாவது பிளான் கொண்டு வந்தாங்கனாலும் இப்போ ப்ராஃபிட் இல்லை லாஸாக தான் இருக்குது அப்படின்ற மாதிரி சொல்கிறாங்க. டெக்னாலஜி டெவலப் பண்ணாலோ இல்லை இன்னொரு பிளான் அவங்க கொண்டு வந்தாங்கன்னா அதுக்கு நாங்களே ஃபுல் ஃப்ளெஜ்டாக ஒர்க் பண்ணி இன்னும் நாங்கள் வந்து அதுக்கு இப்போ ப்ரொடக்ஷன் வந்து நிறைய கொண்டு வரதுக்கு நாங்கள் ஹெல்ப் பண்ணுவோம் சார். இதுக்கு நாங்கள் திருப்பி ரீப்ளேஸ்மெண்ட் காஸ்ட்டுக்கு வெளியே போவேன்னா இன்டீரியர் எம்ப்ளாயீஸே நாங்கள் ஹெல்ப் பண்ணி அவங்க ப்ரொடக்ஷனுக்கு நல்லா வரதுக்கு நாங்கள் ஹெல்ப் பண்ணுவோம் சார். இது வந்து எங்களுக்கு ஒரு மோட்டிவேஷனாக இருக்கும். எங்களுக்கு நாங்கள் ஆர்கியூ பண்ணது கிடைச்சிருக்குன்னா
சார் அதே மாதிரி போனஸ் வந்து ஒன்ஸ் இயர் தான் கொடுக்குறாங்க. அதே மாதிரி தீபாவளி கிறிஸ்மஸ் வந்து எக்ஸ்ட்ரா போனஸ் வந்து கொடுப்பாங்க. ஸோ இப்படி கொடுக்குற மூலிமா வந்து எம்ப்ளாயீஸும் நல்லா மோட்டிவேட் ஆகிடுவாங்க, நல்ல அவுட்புட் கிடைக்கும் சார். இவங்க வெளியாட்களை வந்து அப்பாயின்மெண்ட் பண்ணி இங்கே கொடுக்கறதுக்கு எங்கிட்ட கொடுத்துட்டீங்கன்னா ஒரு நல்ல கோஆர்டினேஷனோட ஒர்க் நடக்கும்னு சொல்லுங்கள் சார்.
No. The thing is only this issue is clear. They are ready to give 12%. They will give before Deepavali they will give it. Is it not? Before Deepavali you will give 12%. Before Deepavali they will give 12%. And they may sympathetically consider something after that, some ex gratia. You also increase you strive hard for the benefit or profitability of the company. They will sympathetically consider after some time because they hold their financial constraints. Let them go back to their shareholders, let them go back to their directors and shareholders. And if you are ready, you may accept for 12%. Accordingly, orders can be placed. You may consider something after that because already you are sticking on to 12%. Why this magic number 12%? How you arrived at 12%? Any criteria or any?
No sir, no criteria sir.
Just like that 12%. 12 is your lucky number.
No sir, no sir. இப்போ என்னோட பாயிண்ட் என்னன்னா இப்போ 20% கேட்குறாங்க சார். நம்ம ஏன் குறைச்சிருக்கோம் அப்படின்னா இப்போ 20% கேட்குறாங்க, நெக்ஸ்ட் இயர் என்ன அதிகமாக கேட்க மாட்டாங்க சார். அதுக்கு என்ன சார் இது இருக்கு, ப்ரூஃப் என்ன இருக்கு?
Next year when it comes next.
இல்லை சார், இப்போ நம்ம இப்போ குறைச்சிட்டோம். இப்போ நம்ம குறைச்சிட்டோம் அப்படின்னா நெக்ஸ்ட் இயர் நம்ம அதில் ஒரு 2% கூட எக்ஸ்டெண்ட் பண்ணிக்கலாம் சார். அதுக்காக தான் நாங்கள் வந்து குறைக்கிறோம். அதில் 20% தான் லாஸ்ட், அதுதான் மேக்ஸிமம். இதுமாதிரி கொடுக்க முடியாதுன்ற பட்சத்தில் இந்த வருஷம் நாங்கள் வந்து குறைச்சிட்டோம் அப்படின்னா நெக்ஸ்ட் இயர் போகும்போது நாங்கள் 2% இன்க்ரீஸ் பண்ணிக்குவோம்ல எங்களுடைய போனஸ்ல இருந்து. அதை தான் நாங்கள் மீன் பண்ணுறோம்.
%12% you are agreeing with the full mind. 100%. You file a memo for that. Accordingly, order will be placed. So, 12% they agreed for that. So the list come to an end. Amicable settlement. Thank you very much for the cooperation of the management. Thank you very much.
Thank you, students. The next case is all about the pricing issue. Other than a potato chips company, manufacturing company, and the farmer. So, I want the contract signed with 3 months condition. I want 30 rupees per kg வாங்குவாங்க. But price in market வந்து 60 rupees இருக்கு. So, அதை வந்து அவங்க breach பண்ணிட்டாங்க. அந்த வாரம் இருக்கு. From the farmer side, I would like to invite Sarvana Karthik, Lohesh, and Jayarjan. From the corporate side, I invite Pragati, Snega, and Aishwarya. The session is on.
So may I please? So we are corporate management side. So we have made a contract for providing 10 tons of potatoes. So per month they have to provide 2 tons of potatoes. Per kg it is 30 rupees. We have done a written contract. So now they are saying that they can't issue per kg 30 rupees. They are issuing for 60 rupees since the market price have increased. So according to us, they are violating the contract which is in the written form. So according to our side, we are asking for a compensation for the damage.
Want specific performance or you want, what is your remedy you see?
So
Under Contract Act, Indian Contract Act 1872 gives remedies for breach of contract. What remedy you seek now?
Sir, they have to pay the compensation for per day, sir. For per day, our operation expenses is 5 lakhs. So they have to pay 5 lakh rupees as a damage, sir.
They agreed to supply their crops.
Yes, sir.
For 30 rupees
30
per kilo.
rupees per kg.
Per kilogram.
Yes, sir.
They have not supplied it. That is your case?
So no, sir, they are supplying, but they are asking for per kg 60 rupees as the market price have increased.
But you ended up on a contract with them.
Yes, sir, for 30 rupees.
To whom you signed the contract?
To the farmers.
Farmers means it is a plural. Individual contract or group contract? Who signed the contract?
Sir, we both signed the contracts.
Signed the contract on behalf of the
Group. Our மூணு பேரும் சேர்ந்து தான் சார் contracts.
All three are farmers.
Yes, sir.
Producers of water.
Producers of the crops.
They agreed to supply at the rate of 30 rupees per kg.
Yes, sir.
Now they are demanding more.
So as the market price increases to rupees 60 per kg, they are demanding that they will supply at the market price only.
They are not supplying for 30 rupees per kg. That is your case.
Yes, sir.
Am I right? So what is the remedy you seek for that? Breach of contract. They agree to supply. I am giving you hint. Breach of contract. So what is the remedy for breach of contract? Indian Contract Act 1872 gives certain remedies. Is it not? One is the to resign the contract. RESCIN. Second is suit for resigning the contract you can file. Second, you can file a suit for specific performance. Third, you can file a suit for injunction. Fourth, you can file a suit for damages. Fifth, you can file a suit for quantum damage. Correct? Study Indian Contract Act. So, which remedy among them you choose? Think it over legally.
So we are responding for suit for specific performance.
Pressing the suit for specific performance. So you want the court to give a direction to them to supply 30 rupees kilogram, that is potato, is it not? To you at the rate of 30 rupees per kilo. Now you have a clarity. This is your issue. Your issue is that 30 rupees you ended upon a contract and a valid contract. Is it not? Everything is valid. Then, now they are declining. They are not ready to perform the contract. Breach of contract is there. Correct? So you should present the case in such a way. Breach of contract. So breach of contract, you have to see the remedies under Indian Contract Act. So specific performance is here. You are pressing for specific performance. You want us to issue an order for specific performance. Am I right? They are asking for a remedy for specific performance. You already, they say, you ended upon a contract. So issue here is, why are you, what is your stand on that?
கான்ட்ராக்ட் வந்து 30 ரூபீஸ்க்கு சைன் பண்ணியிருக்கோம். ஆனால் மார்க்கெட் ப்ரைஸில் இப்போ கரெக்டாக மார்க்கெட்டில் வந்து 60 ரூபாய்க்கு போயிட்டு இருக்கு. பொட்டேட்டோஸ் வந்து டிமாண்ட் இருக்கனால 60 ரூபாய்க்கு போயிட்டு இருக்கு. இப்போ இவங்க கேட்கும்போது 30 ரூபீஸ்க்கே கான்ட்ராக்ட் சைன் பண்ணபடியாக நாங்கள் கொடுக்கணும்னு சொல்லுவோம். அப்போ நாங்களோட இன்வெஸ்ட்மெண்ட் காஸ்ட்டையும் நாங்கள் எடுத்தாகணும் அதே டைம். 30 ரூபீஸ்
entered into contract?
Yes, sir.
When you entered into contract?
1 month.
1 month before.
3 months.
3 months before. You read the contract?
Sir.
You understood? All the essential elements of a valid contract are present. Competency to enter into contract.
அப்போ சொல்லவே இல்லை சார். மார்க்கெட் ப்ரைஸ் இன்க்ரீஸ் ஆகும்போதும் டவுன் ஆகும்போது இதே ப்ரைஸ் தான் மென்ஷன் பண்ணல சார் கான்ட்ராக்டில்.
Is it is a specific mention in the contract that if there is a this execution of contract is subject to market price?
No, sir. No, it's
But you full-fledgedly, with the sound mind, with the valid consideration, you agreed to supply at the rate of 30 rupees.
Yes, sir.
You signed it.
Yes, sir.
Sir,
Accepting it. You are accepting the contract you have signed it.
Yes, sir. First month only the market is 30 rupees.
Sir, you are entered to a contract.
Yes, sir.
You are entered to a contract with these people to supply at the rate of 30 rupees. Have they paid any advance to you?
Yes, sir. Accept in as a second. Advance pay பண்ணாங்க sir.
Have they paid any advance? Have you paid any advance?
Yes, sir, we made an advance.
How much you paid?
1 ton ஓட price மட்டும் advance pay.
How much?
1 ton. Yeah. அவங்க வந்து 20.
How much amount you paid?
5 lakhs.
You accepted 5 lakhs from her?
Sir, நான் ஒன் டைம் சென்ட் பண்ணிட்டேன் சார். இப்போ மார்க்கெட் ப்ரைஸ் வந்து ஒன் டைம் சென்ட் பண்ணிட்டேன்.
Sir, market price fluctuation have you mentioned in your contract?
சார் அவங்க வந்து 60 per kg தான் வந்து சப்ளை பண்ணுவேன் அப்படின்னு இப்போ சொல்கிறாங்க சார். பட் we have already made our financial statements and we quote amount for our raw materials. இப்போ வந்து எங்களால் வந்து ஒரு 1 month டைம் ஃபுல்லாக வந்து எங்களால் அவ்வளோ பெரிய அமௌண்ட் வந்து திருப்பி வந்து அரேஞ்ச் பண்ணுறதுக்கு ரொம்ப கஷ்டம். அண்ட் அவங்க வந்து ஹோல்சேல் பெர்ஸ்பெக்டிவ்லேயே பேச மாட்டாங்க சார். அவங்க வந்து ரீட்டைல் பெர்ஸ்பெக்டிவ்ல மார்க்கெட் ப்ரைஸ் டு த கன்சூமர் அந்த ஆஸ்பெக்ட்ஸ்லேயே பேசிகிட்டு இருக்காங்க. பட் தே ஹேவ் சம் ஹோல்சேல் ப்ரைஸ் வித் தெம் சார். ஸோ வி ஆர் ஆஸ்கிங் ஃபார் தட் ப்ரைஸ்.
Legal stand, I think you are right. You had a valid contract.
Sir,
all are adult who was signed the contract, all are adult. Completed the age of 18 years.
Yes, sir. We all are majors.
Consideration is there. Sir, you entered into your contract with them. So, suppose you commit a breach of contract, what will happen? How you are countering that? How you are going to counter? Wholesale retail is not mentioned in the contract, sir. What is the contract says? You have to supply at the rate of 30 rupees per kilogram. You signed in it. Have you signed it? With the full might? There is no undue influence. There is no coercion. There is no misrepresentation. Sir, market price are you mentioned in the contract? Then where is the... How you can raise the legal question on that? How you can... You think it out, sir. Contract, sir. An agreement enforceable by law is a contract. They are seeking specific performance. So if you... It's a very clear-cut case. It's a very straight case. Your case is very weak, sir. They are put in their stand. Even though the court made enough this thing to bring that it is a specific performance. The supplies are only thing, if you want, you can negotiate in the next time, or you include that in your contract clause in the next time when you are entering into contract. Will you consider sympathetically anything in the interest of their agriculture? They say their production has been, cost has been gone up. You are not raised at that point. You should have told production cost has increased. You are selling market price. So you are very greedy in grabbing the market price.
Sir, market price increase demand அதிகமானனால வந்து எங்களோட
Sir, have you mentioned in your contract these things? Without mentioning the contract, how you can raise the issue? Is it legally, is your argument or legally sustainable? Will you consider anything to them, some special packages?
Yes, sir, we consider.
Sympathetically.
Yes, sir, we consider sympathetically. As our potato is our major raw material, we go for a negotiable price.
Now
For
you
a
are
reasonable price.
What you are going to give to them, what package you are going to give to them. They say 30 rupees you are ended upon a contract with them. They are legally, they have the legally duty to supply to you. But now, what the court asking you is that, is it in the interest of the agriculturist? They say they are the agriculturist. Will you ready? Will you or can you give something to them as a special package? Is it possible?
Sir, per kg க்கு நாங்க
not. Legally, no. You are not entitled for anything. There is no legal entitlement. There is no legal entitlement. But they may consider you sympathetically. They are kind enough to consider you sympathetically. They may consider. So, the court is going to pass an order for specific performance. They are supposed to supply the agreed quantity at agreed price at a specific time. Whatever extra, it will be out of SOC, settlement outside court. You may give separately whatever you want to do. Otherwise, we may pass the order. Specific order will be passed. I am passing an order to supply for the rupees. So you ended upon a contract, specific performance. Specific performance for specific performance according to Indian Contract Act 1878. Breach of contract, they are asking for specific performance. So I am asking the synthetically if they are ready to give anything to make us. Otherwise, no. Because legally their side is unfavorable. SOC, they say SOC, settlement outside court. They are ready for SOC. Settlement outside court, they are ready. But the court may either pass an order or we will keep it in abeyance for a while. If you are ready for SOC.
So, from our side, we face a lot of laws.
No, now the issue is gone. Now it is come to the conclusion. Whether shall we pass an order for specific performance or you are ready to settle outside court.
So, we can go for the specific performance. Pass the order for specific performance.
So, order is served.
Yes, sir.
Yes, I have a comment on this. Those who are studying Contract Act, before you come out for an issue, you should study the Act properly. Because basic thing of a contract is breach of contract and remedies for breach of contract. So there is a scope for improvement in that. Otherwise, what?
Sir, can you give us a concluding remark for 5 minutes?
Sure.
Concluding remark for this debate session, sir.
I will come there. Thank you very much for your patient listening. Exactly, it simulates many times a court atmosphere. Because the backside speaking and all is happening in the court also. So we are unused of that. And first case is concerned. Well, my first comment is that as a management students, it is a very good attempt by both sides. Both sides attempted very well. In fact, we cannot expect the standard of a lawyer or a judge within a single attempt, because wrong is not made in a case. So what my suggestion to you is that in future, this comment is, first of all, whatever comments I am making here is not against any individual, not against any group. Their work is, their presentation only will be analyzed, not the person. Whatever I am speaking, kindly don't take it personally. And only your 2 minutes presentation here only, I am analyzing. So I am taking a caveat before I am making a comment. I am making a caveat in presence of seniors. Because first case was a bonus case. So first of all, my suggestion is that if at all you go to any judicial body or a quasi-judicial body, Fact definitely will be clear about the fact. Facts will be clear. But what is the question of law? Which side the law stands? That has to be looked into. That is an ultimate job of an advocate or a solicitor. That is an ultimate job. First of all, you should know where is the legal stand. See, bonus issue is concerned, the trade union, those who are representing the trade union, they are not aware of, that is what I felt, they are not aware about their limitation. And the management side also, I have a comment on the management side also. They could not able to explain why this specific percentage of 12 has been formulated. Normally the top icons are sitting here, those who are in the top management, they know. Management, everything speaks by the figures, not by the, because I had the opportunity of working in corporate also. Everything, each and everything, the figures that speaks. Not that the whims and caprice. That is in, whims and caprice will be our normal parlance. Because I like you, I am going to give 12%. I am sympathetically considering you. See, business means it is pure based on the facts and figures. There is no place for sentiments in business. Court may consider sentimentally. Employees will suffer. Employees will suffer. If they give also, employees is going to suffer. If they take a loan for an overdraft and pay to you, after some time retrenchment will come. Some of your colleagues are going to affect. That is, that will be fatal to you. That will be fatal to you. So, my suggestion, if at all there is a next program, first of all, you pre-plan in this manner, this structured manner, which I am given to you. First of all, you form the issue, then you form what is the rule, then how you corroborate it. Where is your violation? 8.33% is there. Already there will be some, have you submitted the COD before that? All this question I asked you. Because you are a new, you may not be knowing, there is a procedure called, because I already worked in corporate sector, MSR will be knowing better than me. They will give a COD because I am directly handling with the HR and the labor. So they will give a COD to us, charter of demands. That is a normal exercise that they will do all these things. They will, but in my experience with speaking to trade unions, what I understood is that they are very thorough people. Trade unionists are very thorough. We will not be able to defend their, we will not be able to defend their ideas. They will push me to the corner. Most of the time I will be pushed to the corner. He may be an uneducated person, he may be 10th standard or +2. But their knowledge about the labor law, their knowledge about the Supreme Court judgments and High Court judgments is something extraordinary that I have experienced in my experience in corporate world. So my humble submission to my young friends is that before you, suppose you are representing a labor side, you can represent, need not be an advocate. In management side, you should be thorough. How you are able to 12%? They will push you to the corner. Trade unionists are very smart. They will push you, they will make you decide it on the spot itself. You are the victim of, many management people are the victim of that. So second, they are very cunning. They are seasoned people. You are seeing only, you may be new, but they are seeing many people. They are seasoned people. Understood? So that is my humble advice or suggestion to my young friends. Second point, the specific performance is concerned. The people who are represented the company side, there is some scope for improvement. There is some scope for improvement in their legal aspects. Factual figure you are making, but before that you have to submit in the Indian legal system, you have to tell your prayers correctly. If the prayer is wrong, court cannot, court cannot substitute or court cannot supply your prayers. Court is incapable of supplying the prayers. That is what happened only in Philips. Suppose your prayer is not for specific performance. They are going asking compensation. Where is the word compensation? Indian Contract Act 1872. Indian Contract Act 1872 speaks about damages. That is a legal word. Damages, things which can be expressed in terms of money. So you need money. You you have a specific remedy. When you have a specific remedy, don't go for non-specific remedies. When you have a specific performance, suit for specific performance, stick on to that. You will never come back from the argument. Specific performance. Let them supply for 30 days. Let them supply. Because they are agreed. They are signed, sealed. There is no agreement. Agreement has reached a stage of contract. This is not. You know the difference between agreement and a contract. All contracts are agreements, but all agreements are not contracts. That is why he specifically given a clue to them, whether it is an agreement or contract, but they say it is a contract. I try to, like you, I try to patch them up also. I try to patch up them, but they do not catch the thread which I am trying to put. Because normally when you go to the normal court proceeding, suppose we are sleeping, judges will give threads. You catch that thread and try to come up. Or they may say you need some time to think it out. Can I put this case tomorrow? Because they are so your mind should immediately something should reverberate in your mind. That is, I am wrong. Nothing wrong. You can amend the plate. You can amend the petition. Amendment procedure is there. Court will accept you. Only thing other side will not accept. That can be overruled by speaking to the court. So this is my comment on this. Otherwise, very good, excellent. I am very happy to interact with you. All the best. And expecting. And also one second. Thank you for giving me an opportunity. Thank you very much for MS and other senior people for giving an opportunity to address this young crowd. I am very keen in future also. Whenever there is an opportunity, I will be here. And in fact, I am honored by it. Thank you very much. Thank you.
Thank you for your comments, sir. Now I would like to invite Harini to deliver the vote of thanks.
It was a wonderful session. I would like to thank the students who actively participated in the seminar to make it more interesting. I would like to thank our honorable guest speaker, Mr. Dinesh Kumar sir, and our head of department, Dr. M. Subramanian sir, and our management faculties for conducting the seminar, which helped us to gain knowledge. And I could also like to thank our beloved professors and my friends for being a strong support in conducting this seminar successfully. Thank you all once again.
Thank you, Harini. Now we request all to rise for national anthem.
Thank you for the